Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murdersheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
This season, Instacart has your back to school. As in, they've got your back to school lunch favorites, like snack packs and fresh fruit. And they've got your back to school supplies, like backpacks, binders, and pencils. And they've got your back when your kid casually tells you they have a huge school project due tomorrow. Let's face it, we were all that kid. So first call your parents to say I'm sorry, and then download the Instacart app to get delivery in as fast as 30 minutes all school year long. Get a $0 delivery fee for your first 3 orders while supplies last. Minimum $10 per order. Additional terms apply.
Have you ever covered a carpet stain with a rug? Ignored a leaky faucet? Pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
Content warning: this episode contains discussion of the murder of 2 girls.
Well, no great surprise here. There have been more filings in the Delphi murders case, or more specifically, the case against Richard Allen, who, as we all know, has been charged with the murders of Liberty German and Abigail Williams. At least for the moment, the trial in that case is set for the middle of May. So as we get closer to that date, we should expect to see more and more filings of more and more interest to us. And let's talk about the most recent ones.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders, a response, an objection, and a motion in limine from the state. So to start off with today, we'll go through the one document that's not from the state. This is actually from the defense, specifically defense attorney Bradley Rosie, who, of course, is half of Allen's defense lawyer duo, along with Andrew Baldwin. So he filed some documentation subpoenaing a man named Lacey Patton Jr., who was one of the inmates that Richard Allen was incarcerated with who Richard Allen allegedly made incriminating statements to. And it seems like Mr. Patton is currently incarcerated in the Elkhart County Jail, and Rosie is trying to depose him, noting that he would like to depose him with Special Prosecutor James Luttrell, as well as court reporter Sharon Barrett. And now, not only this, but we have some forward-looking statements where Mr. Rosie wants Patton to also testify at trial on May 20th at 8 a.m. So we're seeing not only last-minute depositions, but also maybe some forecasting for what we'll see at trial.
Very interesting. I'm sure Patton's testimony will be potentially of interest to us all.
Yeah, this seems like one of the folks who.
We know that this is somebody who heard things, or is this somebody that's going to talk about bad conditions, or both?
Yeah, it could. I mean, the defense could use him to say, well, maybe this confession wasn't very good or accurate, or maybe Richard Allen was under a lot of stress. So, I mean, it's not like they can possibly twist some of the stuff around, I think, to benefit them if they're thoughtful about it. But I think the sheer number of incriminating statements is definitely something that still puts Richard Allen at somewhat of a disadvantage here, in my opinion.
Yeah, I think I would agree.
Somewhat of a disadvantage is probably a mild statement, but
yeah, very mild, very mild indeed.
Yeah.
Do you want to move on to some documents filed by the state?
Yeah. So the state's response to defendant's motion to compel and request for sanctions filed April 23rd, 2024.
So this one, mouthful of a title.
Yes.
Basically, this is about discovery issues. And you remember that the defense said, oh, the state has done such a bad job getting us discovery materials. They need to be sanctioned and not allowed to talk about certain things at the trial. And so this document, which you've just referred to, is basically the state's response to the claims that they have mishandled the discovery process.
Yes. Two interesting little snippets. We're not going to use our sound effect today, but we're going to just be doing quotes. But quote, not all information gathered in an investigation is discovery. And then again, this is a portion of a quote, but quote, thousands of tips and hundreds of investigated leads. So one thing that we've emphasized over time, and this is something we've gotten to know as we've covered the Delphi case, but the Delphi case is a huge case when you talk about information gathered. There's a veritable ocean of information, many, many different people who came up as persons of interest, or just somebody who was like tipped into the, investigators that they had to look into and cross off the list. There's a ton of information, in other words. And in addition to that, there's also, I guess what I'm trying to say is that it's a huge amount of discovery. So we've often commented that we feel like both defense and prosecution is likely drowning in it. In addition to that, I think it's very important to what McClelland is saying in the beginning here. Not all information gathered in an investigation is discovery. Discovery has to do, I believe, more with, what's going to be used at trial, what could be exculpatory, things like that. It's not necessarily discovery if, like, some random person is, like, pulled over that day and, like, it has nothing to do with anything, right?
Yeah. Or if I call in and say, oh, I think my Uncle Joe might have been involved with the murders, and Uncle Joe turns out was vacationing in Honolulu that weekend, then obviously Uncle Joe has been cleared. That's not going to come up in trial. It doesn't really affect the innocence or guilt of Richard Allen. And so that wouldn't necessarily need to be turned over to the defense.
Right. So one thing that's always struck me that a little odd about the defense when they discuss discovery is, on the one hand, they seem to be complaining that, they can't find certain things. Oftentimes not necessarily directly accusing the state of not handing it over, but just saying they can't find it. And then occasionally accusing the state directly. But that's that's coming out of one corner of their mouth. And then the opposite is basically accusing the state of drowning them in discovery and giving, how are we supposed to do any of this? And it just seems like that's kind of the job. The job for them was to figure out
So basically,
to get their arms around discovery.
They're saying you're not giving us enough in a timely fashion, and on the other hand, they're saying you're giving us way too much.
But
and we're drowning.
It's not, and it's like that's their job. It's their job to parse through, figure out what's important to their client's defense. And that's always baffled me, because it's like I think it's reasonable to complain about the first one, perhaps, even if you're not entirely sure if it's really missing, just to, get some points. I don't know. I can understand that. But the latter one, it's like that was always going to be the Delphi case. It was going to be dealing with a lot of discovery and figuring out how do we organize that. And reading between some of the lines, I don't know that the defense has actualized upon organizing any of this. And that makes me incredibly concerned for this May trial date, to be perfectly frank. Because I would think you would really want to have a grasp of everything that you have going into this.
Yeah. I am concerned that the defense is not as fully prepared for this mid-May trial as I would like to see.
Which they've asked for with their speedy trial motion. So the pressure that is being put on the defense right now, time-wise, is coming from, the calls are coming from inside the house, to use the common parlance. That they are doing this to themselves, and they have proffered reasoning for this by saying, well, their client is doing so poorly in Westville. I don't know how compelling I find that, to be perfectly blunt. I think, it's definitely a better outcome for Richard Allen to be acquitted, than to hurry along to trial and get convicted. Because then he's definitely going to be staying in prison for a long time. If he's acquitted, they can get him out.
Point 5 of this document gets to something you were just talking about. I'm reading from point 5. Throughout this process, the defense has inundated the state with inquiries on where to find certain documents. The state has endeavored to assist the defense in finding documents that they are looking for and the information provided to them. Oftentimes, in this endeavor, the state finds that the defense had the documents all along, but they could not locate them. The state has no idea why the defense cannot locate the documents. So
this all sounds like somebody like helping out their elderly parents with technology or something. Like, where's this? Where's this folder? It's like, oh, it's right here. This is not the prosecution's job to hold their hands through this. It seems like, from what McClelland is writing here, that they maybe have gone above and beyond to hold their hands through some of this, but that's to be very clear, that is a courtesy.
And McClelland in this document is indicating that they have actually spent a great deal of time and effort trying to help the defense find documents that have already been provided to the defense.
I mean, that's ridiculous to me. And it's then especially ridiculous to have that be the case and then be complaining about it.
McClelland writes, basically, the state took hours out of its week to do the defense's work for them so that it was as convenient as possible for them to access the information they requested. He further writes, all the information requested by the defense was already in the possession of the defense. So that's also a little embarrassing. It reminds me of some of the filings we had earlier where the defense made some assertions about geofencing, and then there was a response which indicated bluntly that the defense didn't seem to know what they were talking about on that matter. And I think this gets back to what we're saying. They don't really seem to be fully prepared. And if you go into a trial when you are not fully prepared, let's be blunt, the odds go up dramatically that you're going to lose.
Also, it's not fair to your client, not at all. And in addition, I mean, they've put their client in a position where I think he would have a heck of a time arguing incompetent counsel, because he basically, I mean, as far as the courts are concerned, he basically refused to go on without them. He fought for them. He brought them back on. That's a self-inflicted injury at that point, so it really is incumbent upon Rosie and Baldwin to do the absolute best job they can, because, I mean, this guy, Allen, he put it all on the line for them, and it's not like, I mean, I don't really see how he can argue incompetent counsel at that point. I mean, that was even discussed in the Indiana Supreme Court hearing over this, where, I mean, I felt, without necessarily directly saying this, his appellate team were basically like, oh, well,
And let's be blunt. According to the state, this ballistics evidence links Richard Allen to the actual crime scene. Richard Allen has also, by his own account, put himself in that vicinity at the time of the crime. He has confessed to literally dozens of people, or at the very least made incriminating statements.
Let's say made incriminating statements, because to me a confession is a little bit more comprehensive. But nonetheless,
he's made incriminating statements to dozens of people. These are what they call bad facts. The vast majority of the time, if you have dozens of confessions and or incriminating statements, and the defendant puts himself at the crime scene, and there is physical evidence which plausibly links him to the actual murder site, you're in the vast majority of cases, you're looking at a guilty man who is going to be convicted. And whatever chance you have to get an acquittal will depend entirely upon the skill of the lawyers and upon those lawyers being fully prepared. And it feels whatever chances they have to get the verdict they feel is best for their client, those chances go down dramatically if you go to a trial underprepared.
Very well said. And I mean, what Kevin and I would love to see is really good lawyering, as we've said before, on both sides, and a great legal combat, I guess. But the closer we get, I mean, we're not going to sugarcoat things for you. I mean, that's not what we do here. And I think our listeners understand that and realize that we're giving you our opinions here, not because we're trying to sway you to one side or another. It's because we're legitimately concerned going into this. And it's taken a while for us to even get here. But there's been, looking back in history with this case, there have been times that maybe caused concern, and we've said, well, let's give them the benefit of the doubt. And that has been stretched to its limit. And at this point, we just want to just be completely blunt about how concerned we are going into this, because we're not doing anybody any favors by not revealing that, in my view. And we're not doing, this is an analogy I'd use if we're talking about like a weatherman, a meteorologist. If you're having a sunny day or just a normal rainstorm, you can talk about that normally. Okay, like here's the rain, here's how, bring your umbrella. But if you take that same tone and approach when there's a huge nor'easter bearing down on your town that's causing flooding that could endanger lives, then you don't do that. You don't say, well, consider taking an umbrella. You say, stay inside. Like, if your house starts flooding, get help. Like, and that's kind of where I feel we're in a bit of a nor'easter right now. And I hope that the defense maybe is in fact quite prepared, and perhaps we've gotten the wrong idea. But seeing some of these filings, I really don't necessarily believe that.
Getting the smile and confidence you've been dreaming about, all from the comfort of your home, isn't a total mystery with Byte clear aligners. Just don't be surprised if all your friends start asking, what's your secret? Begin by ordering your at-home impression kit today for only $14.95. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
We've got a lot of ground to cover in other documents, but before we move on to the next one, there is one more thing I would like to highlight in this particular document, and this is where it covers Todd Click. As we all know, Todd Click sent a letter to Prosecutor McClelland indicating that he had concerns. He felt that perhaps Richard Allen wasn't guilty, and perhaps the real guilty parties were these Odinists, and he sent this material to McClelland, and the defense is very upset because they say McClelland then took months before he passed this on to them.
And Todd Click, to be clear for those, whom were like, wait, who's that guy? Former assistant police chief to Rushville, Indiana. And I would characterize him as a star witness for the defense because he worked on the Odinist theory early on and is able to provide that sort of like, I'm a law enforcement officer, I believe this theory, sort of a seal of approval, I think,
Right.
that the defense is looking for.
And so, as I indicated, there's things the defense has complained about. I want to read in full paragraph 15. Actually, why don't you read that?
All right, sure. So, quote, that the state did not delay turning over evidence from Todd Click. The state turned over a report from Todd Click to the defense that was not discovery, but was information gathered in the 6-year investigation. Further, much of the information in the Todd Click report was duplicative of the information in the Indiana State Police reports turned over to the defense months prior. Plainly, the defense had the information in the Todd Click report all along because it was duplicative of what was in the Indiana State Police reports. The Indiana State Police had documented the same information that Todd Click documented, all of which is irrelevant because the information was received in both forms by the defense well before any trial date.
So that's pretty compelling. They're saying whatever Todd Click wrote, you got well before the trial, plus you already had that information in another form. We always talk about Anya's problem stealing cereal. Let's say that there are 3 Indiana State Police reports where they've interviewed witnesses who saw her stealing cereal and leaving the scene of the crime. And then later on, months later, the police chief of Rushville sends the prosecutor a letter saying, those statements from the Indiana State Police with those witnesses, that seems pretty important. It makes me think she's definitely guilty. But the fact is, he's just summarizing stuff that they already have. And so if I get a letter saying, these reports about Anya stealing cereal are interesting, if I already have that raw information, it doesn't seem quite so crucial that I also have this particular man's take on that information, because what's important is the actual information from the actual reports.
This also raised a red flag to me because of the note that basically Indiana State Police already had all this information and included it in reports. And the reason for that is that I can see an argument to be made for the Odinist theory if there's really like a documented, we tried to tell the Indiana State Police and they just wouldn't hear us out and they didn't document any of this. And that seems to be what the defense has been saying in the past. So, that would be, to me, good for the defense because you could say, well, the Indiana State Police didn't properly investigate this. But if they have all this information and they don't think it's compelling and they didn't think it led to probable cause, but they documented it and it's in reports, then that narrative becomes much murkier to me.
Makes a lot of sense. Are we ready to move on?
Yeah, let's go to the state's objection to defendant's motion to suppress, filed April 15th, 2024.
And once again, Anya has accurately read the mouthful of a title, but let's just say what it's really about. What it's really about is Miranda, custodial interrogations. Richard Allen went to the police station and he had a conversation with Jerry Holman. And the defense says, we think he wasn't Mirandized properly. We think he was in a custodial situation. We think those statements should be suppressed.
Yeah, so Jerry Holman is, of course, a lieutenant with the Indiana State Police. He's one of the investigators who's been on this case for a very long time. And, I think one thing that's important to understand with Miranda warnings is that there are certain essentially rules about when one is needed. And one of the sort of, points of contention between the prosecution and the defense in this case is custody. So a Miranda warning should be given when a suspect is in custody. And what does custody mean? And there can be some gray area with that. It's not always, obviously if the state police burst in here right now and arrest Kevin and me, we're in custody because they've arrested us. But is it custody if you are, in a police station giving a statement and you kind of feel like you're in custody, or you feel like you can't really get out?
If the police say, Anya, we'd love for you to come down to the police station. Let's just have a fun conversation about cereal. And she comes down there on her own and she starts having a conversation. And in the course of the conversation, maybe she starts making admissions or saying damaging things.
As I am wont to do.
Maybe she doesn't feel free to leave. And the session ends with her being formally arrested. At what point does she become in custody? That's basically what we're talking about.
And so
here.
there's nuance here. So I think a lot of us, including myself, frankly, you think like, oh, Miranda warning is automatic in every situation because that's what it looks like on TV. That's what I sort of thought. But there's wrinkles, there's nuance, and there's also nuance on the defense side where they can argue, well, listen, maybe it wasn't like officially stated, arrest type of custody, but my client felt like they couldn't leave, and here's why, and then maybe it is custody. So you can make arguments, I guess, is what I'm saying on either side.
Earlier when we covered the defense filing, we talked about their characterization of this interaction. They said, oh, Jerry Holman's a really big guy. Richard Allen's not.
He's a little guy.
There were hallways, there were doors. What can you read paragraph 1 of this where we get another description of these interactions?
Absolutely. Quote, that on October 26, 2022, Richard Allen came to the Indiana State Police Post in Lafayette to talk about the return of his vehicle that had been searched. He came to the post voluntarily under his own volition. Once he arrived at the police post, he was asked to speak with Lieutenant Jerry Holman. He was taken to an interview room where he was informed by Lieutenant Holman that he wished to speak with him about the results of the search of his home, but that he was free to leave at any time. The interview room consisted of 3 chairs and a desk. Lieutenant Holman was the only law enforcement officer present in the room. The doors were not locked, and for Richard Allen to leave, he only had to exit the interview room, travel down a short hallway, and exit through a set of doors in the lobby. None of the doors were locked or required assistance to exit. Before Lieutenant Holman spoke to Richard Allen, he reminded Richard Allen that he had been advised of his rights back in October 13th, 2024, the last time he spoke with police. Richard Allen affirmed that he understood his rights and sat down to speak with Lieutenant Holman. The interview lasted approximately 60 minutes, during which time Richard Allen was given multiple breaks where Lieutenant Holman left the room, leaving Richard Allen unattended. At one specific break, Richard Allen left the interview room to use the restroom and to go outside to smoke, and then returned to the interview room to continue the discussion with Lieutenant Holman. At no time during the interview did Richard Allen get up to leave, nor did he display signs of distress or undue influence. Richard Allen sat through the entire conversation with Lieutenant Holman and participated in the exchange, even after saying he was done talking.
So that doesn't paint a picture of a person who feels intimidated and in custody.
If he went outside to literally smoke, then yeah, I mean, also that shows that you absolutely know how to get out, right?
And also, I think it's worth repeating the point we've made in earlier episodes, as I think most of you know, Anya and I became a part of the story when we got the crime scene pictures and we ended up doing an interview with Lieutenant Holman at the police station, or the state police post, I guess is the technical term. So we were actually in this room. We were actually in this interview room where Richard Allen was talked to. And this description is accurate. It's not a big room, but it's not necessarily a tiny room, and it's not hard to get to. It's just a little hallway, and then you're back in the lobby, and then a moment later, you're back in the parking lot.
I think there's an argument to be made if a person who is being interviewed really feels like they can't get out. Like, how am I going to get out of here? Like, this, like they're going to have to unlock a door for me and then scan me out. You can make an argument that that is a custodial situation because the person is intimidated by the process of leaving, right? It's like almost they're locked up. But I do also believe that this description of this room is accurate. And if he was already leaving for smoke breaks, you know, and I'm going to just say this, in the defense filing, they emphasized a lot about like how big and scary Jerry Holman is. and we sort of rolled our eyes about that a little bit in that hearing. And I understand that they're trying to emphasize, like, it's scary for Richard Allen, therefore it is a custody environment. I think they would have been better off emphasizing, I guess, Holman's status as a police officer, a state police representative, a lieutenant who's been, doing this for a long time and therefore might be intimidating because, like, oh, I'm going to do what they say because he's, a police officer. I think that would have been a better move than to say he's tall and our guy is short, because what's the remedy for that? I mean, again, what is the remedy for that? To have a short police officer on hand in case they have a short suspect?
And also, again, let's be blunt. Talking to a police officer in any circumstance is inherently somewhat stressful. And there's nothing you can do about that. That's just the way it works. We were not under any suspicion of any crime when we went in there and talked to him. It was a little bit stressful. If you get pulled over by the police for speeding, that's stressful. You can't do much about that.
You can call a lawyer. That would be smart.
Yeah.
That would be a good move. But I mean, but as far as like what constitutes custody, that you have to rise to a level to achieve that. And that doesn't come out of someone being tall. That comes out of, I guess your status as a police officer. And I didn't feel like they emphasized that enough.
They mentioned in the filing that, that when Richard Allen was given the reminder of his rights, that did not get recorded, but they mentioned in the filing that this was observed by Detective Dave Vito, the Indiana State Police. So then we have another witness who says he saw that. And why don't you read paragraph 8?
Quote, that Richard Allen's demeanor in the interview is that of a person who is not under undue influence or coercion. Even when Lieutenant Holman raises his voice and makes accusations directed at Allen, Richard Allen remains calmly seated, continues to answer questions, and does not leave the room, and never attempts to leave or expresses a desire to leave. Further, it is clear that Richard Allen is aware of his rights and understands his rights because at one point during the interview, he tells his wife that requesting an attorney would terminate the interview.
I think that's really telling.
Yeah.
I think Richard Allen saying that demonstrates that he had a relatively sophisticated understanding of his rights. So he knew what his rights were, and he knew what he could do to terminate this interview, this whatever you want to call it. He knew what his rights were.
So does this damage the defense's claims that he was not properly Mirandized?
It feels to me that it does, because number one, he seems to be aware of his rights. And number two, they don't really paint a picture here of a person being in custody. And again, for the sake of Miranda, you need to be in custody for Miranda to be required.
Yes. And so, yeah. And again, it's like, once again, Richard Allen saying something has harmed his cause. This is why lawyers emphasize that you need to bring in a lawyer if you're in this situation.
It's not just because lawyers like ourselves like getting money.
No, it's not because they're trying to wring every dollar from their clients. It's because they care.
That's just a side benefit.
Yeah, it's because they care. No, it's because, I mean, but it is true. If you're, I mean, especially with such a serious case too, I mean, you don't know what you can say that could end up being, a pretty big problem later on.
I think before we wrap up this document, you indicated you want to talk about a couple of the cases that McClelland cited. Well,
I thought that the defense did a good job in their filing, citing a case that was relevant, where they basically talked about, and it was a case that Andy Baldwin actually worked on. So it was a man who was brought in on suspicion, I believe, of child molesting, and they were able to successfully argue that that person was in custody, even though he wasn't formally under arrest. And so I'm going to read some of the points that McClelland cites, kind of countering the ER case, and then cases that he feels are more on point. So, quote, the facts in this case are quite distinguishable from the facts of ER presented by the defense. In ER, the court emphasized the circuitous path that the defendant would have had to navigate if he chose to leave the interview. The court described it as a labyrinthine exit route with many obstructions to egress. This would, in the court's view, greatly discourage the suspect from leaving the interview room. In contrast, Allen's exit involved a short walk without multiple hallways or elevators to navigate. Further, the ER court emphasized the impact of having 2 officers present during the interview as opposed to 1 officer, which occurred in the interview of Richard Allen. Quote, so that gets into some of the differences. Basically, like, ER may have understandably felt like he couldn't leave because, like, how am I going to get out of this building? Whereas that's not the case here. Let's go into some cases that McClelland feels are more on point. Quote, the facts of this case are more akin to State v. Diego, where although the interview occurred at a police station, Diego was not under arrest or in custody. He arrived at the station on his own. He was advised he could leave at any time. The path to the exit did not require assistance, and he was confronted with case facts and evidence, some of which was not true, after which he made incriminating statements. In Diego, the court determined that given the casual atmosphere, exploratory and conversational line of questioning, and relatively unimpeded pathway to the room, the totality of the circumstances were not indicative of a custodially interrogation requiring Miranda. I think there might be a typo there, but anyways. So this is talking about a different case that where basically the court said this is not, a problem. And another one they brought up is the case of Light, which got into quote, the court ruled that his interrogation was only 4 hours. Evidence showed Light was of sufficient intelligence to understand his rights, and officers lying about certain evidence against Light and even questioning that, positing Light's guilt in every question, storming from the room when the interviewer did not like the answer, did not amount to police coercion. So that's a case where there was a 4-hour interview and it was very contentious, and police lied to the suspect, and it was still allowed to stay in. I mean, as we've talked about, police can lie. That's within the rules of an interview. Not on the stand under oath, obviously.
Obviously.
But in the course of an interview, that's been upheld by the courts. So, they're offering a different view. Again, I thought that some of the defense's points around ER were pretty good, and I'll be curious to see what happens, but it seems like some of these additional facts don't seem to indicate a custodial environment, in my view.
What's the final document we're going to be discussing?
Going to be state's objection to defendant's motion to suppress, filed in April. Or no, did we already do that? No.
We already did that.
I'm lying. It's actually a motion in limine.
Motion in limine. Again, Anya has given us the title of the document correctly, but she has given us no useful information as to what the actual contents are. So a motion in limine that's a fancy way of saying these are things that our side doesn't feel should even be mentioned in court. Shouldn't even come up in court.
Don't even worry about it.
Don't worry your pretty little head about it.
So,
and let me say, as we go through this, there are some things in here that I think are reasonable, and there are some things in there that I think are a bit of an overreach.
And I'll say this: my take on this document, just to get started, and you'll probably see it as we unspool it, but I think that this document could do 2 things. This could be the prosecution's attempt to preempt grandstanding that they anticipate from Andrew Baldwin and Bradley Rosie, and also, if it goes a certain way, could be the death knell of the Odinist theory in trial.
Let's start at the beginning. I'm going to read a couple of the first things here. And again, this is a list of things that McClelland says this should not happen in court.
Don't let this happen in court, Judge.
Number 1, any comments about counsel for the state that constitute a personal attack on the attorney for the state, or comment on the roles of the state's attorney. Any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. Any innuendo or inference that is not supported by admissible evidence. And I have to say, it feels embarrassing that you have to ask for those.
I think it's reasonable to ask for those in this case, though.
But it's embarrassing. It's like if Anya and I are going out to a nice restaurant and she says, now, Kevin, I don't want you to eat with your hands. I don't want you to just throw your food around willy-nilly. I want you're asking for things that are basically accepted standards of behavior here.
Yes, but I don't think that acceptable standards of behavior in this case have been consistently met by the defense. To be blunt.
Can you read points 4 and 5?
Quote, any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issue in the case. Any attempt during voir dire to have the jury prejudge the credibility of a witness.
So what is this referring to?
Well, I think I know. One thing that when we profiled Andrew Baldwin, one thing that we heard a lot from his colleagues was that he likes to do mini openings in voir dire. So
this is basic. We actually saw him do this.
We saw him do this. We saw him do this in the Randy Small case. So
what's a mini opening?
Well, why don't we explain what voir dire is? That is when you select the jury. You have an opportunity to question jurors and say, okay, what do you do? Oh, you're a police officer? Get off my jury. Oh, you're another lawyer? Get off my jury. Oh, you have strong opinions on child molestation? Get off my jury.
It's a fascinating process. And if you haven't listened to it, we don't often try to promote our earlier episodes, but the episode we did on the small jury trial, the voir dire process, I think we go into this quite a lot, what that process is like.
Yeah, and I was pretty impressed with Andrew Baldwin's performance in that voir dire. I think actually that was probably the strongest he was during that trial, where he was really interacting with the jury, connecting with them, making them laugh in certain instances. It's a way to kind of charm the jury and also, weed out people you don't want on the jury. But
so what's this mini opening?
So what he does is he'll almost kind of present his case in voir dire. It's like a shorter, more concise, boiled down version of an opening statement.
It's just like 2 or 3 minutes, right?
Yeah, it's short. But I think the goal is to start the jury early and get them on your side of feeling like they're going to be, oh, this guy's writing some checks and then let's see if he cashes them. And it kind of hooks the jury in to your side of things early on. I think that's the goal.
And furthermore, I think if you're doing a mini opening statement in front of the whole jury panel, you can look and see, oh, this person seems to be
rolling his eyes.
This person seems to be more open to it. It's a way to get more information.
Yes. So, I mean,
it's a clever thing to do.
It's smart. It's a smart thing to do.
So McClellan doesn't want that.
No. Because, this is something interesting. I believe, and Kevin, correct me if I'm wrong, but I believe in Baldwin's mini opening, he alluded to things that were negative about the victim in that case that ended up not being something that were elaborated on in trial. It was just they were kind of like, oh, the victim wasn't this angel, but then they never really went that far with that. And I feel like maybe they kind of got the vibe that people didn't like that, or maybe it was a situation where the evidence didn't really quite stack up there. And so if that's any indication, there's the opportunity to kind of play a little bit looser with what you're saying. And I think McClellan wants to do away with the possibility that there could be things stated there that are not backed up by admissible evidence. Is that fair to say?
That seems fair to say.
Which I understand in this case. So I guess this is another quote from this. Any hypothetical question that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705.
What's Rule 705?
So as far as rules of Indiana trials, Rule 705 is
rules of evidence.
Yeah, rules of evidence. Quote, disclosing the facts or data underlying an expert's opinion. Quote, unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data, but the expert may be required to disclose those facts or data on cross-examination. So this gets into some expert stuff, I guess.
Yeah, so if you have an expert on serial related crimes, they can get up and say, we believe Anya has a serial related mental illness. And that can be it. They don't have to explain how they reached that conclusion. But then the witness, or rather the counsel for Anya, can stand up and cross-examine them and say, what made you conclude Anya has this embarrassing, humiliating problem?
Kevin Greenlee bribed me to say it. Oops. And then, yeah, I've been framed the whole time, folks. That's the twist. So, yeah, that's something that, it's interesting. I think this document is especially interesting because it kind of gives a peek of what Nick McClelland is sort of anticipating going into this.
And I'm going to read point 7. Again, these are things that McClelland believes should not be mentioned during the trial. Number 7, any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. The state requests such order in limine to include but not be limited to the following. A. Odinism. B. Cult or ritualistic killing. C. Brad Holder. D. Patrick Westfall. E. Johnny Messer. F. Elvis Fields. G. Ned Smith. H. Rod Abrams. I. Kagan Klein. J. Jerry Klein. K. Ron Logan.
Some surprising names in there, in my view.
So yeah, he's saying they shouldn't even be allowed to mention some of this stuff unless they have evidence other than rumors that ties them to the crime.
Yeah. So, I mean, this is interesting. It's something that our friends Brett and Alice from the prosecutors have said on their show. Something that one of our other friends, Jason Blair, has said in conversations with us. Is there a possibility that the Odinist theory will not even be admitted because the evidence there is not there? That there's not enough admissible evidence to justify essentially putting the Odinist, or the alleged Odinist, I should say, on trial. In a trial for somebody else.
Well, I'll go to the extent of saying that I believe an argument can be made that if Judge Gull refuses to allow the Odinism material into the trial, she would be doing a tremendous favor to the defense. Because my concern is if you just say it's Richard Allen or the Odinist, if you frame it basically as a choice between two competing narratives of what happened, I think there's an excellent chance that a jury would look at some of the holes that are apparent in the Odinism theory and say, we can't buy this. And if the only other choice is Richard Allen is guilty, I'll go over to that camp.
Yeah. I think you're absolutely correct. I think she would be doing them a huge favor. Also, I think the Odinist theory, as presented by the defense in their filings, has holes that you can just walk through. I mean, like when you have a situation where you're admitting that a guy that we're comparing to Charlie Manson has an alibi in this case, there's some problems there. There's some but on the other hand, as somebody who cares about like fairness, does it seem fair to me that they might just go up there and malign people who there was like no evidence against, as far as like putting them at the crime scene or committing this crime, aside from what they presented, which is largely conjecture and frankly, in some cases, mischaracterized social media posts. So like, do I feel good that they're going to be basically possibly putting them up there to accuse of child murder? The whole thing makes me very uncomfortable. I think it should make any person who's defense minded uncomfortable, because it's like it feels like it's become almost a witch hunt for these people, and one that has all sorts of bizarre, I guess, these people have different beliefs than us. They're other. They're different. They're disturbed, and the whole thing makes me deeply uncomfortable, I guess.
And then I start to have some pretty serious concerns about overreach when we get down to names like the Kleins or Ron Logan, because I think it's pretty apparent to anyone who's followed the case that at different times law enforcement was very, very actively pursuing those men because they suspected them of possibly being involved. So if law enforcement looked at those men and thought, oh, here's some evidence that might tie them to it, potentially. Oh, Ron Logan's, his alibi is shaky. What was this pet store thing? Kagan Klein, was he trying to meet them that day? Those seem to me to be worth mentioning for the jury to consider. And to say you can't even mention this, even though we spent years working on these leads. I don't know, that makes me feel a little uncomfortable. What do you think?
I think you're right. I think if they came up, I mean, frankly, I think Logan and the Kleins were probably avenues that a lot of people thought the defense might go down, as opposed to the Odinist. We haven't really heard a lot about them recently, so it's kind of odd, and it makes me wonder what's gone on behind the scenes where they're coming up now, where McClelland's trying to preemptively do this. I guess the only thing I'll say is I don't know what's going on behind the scenes, so it's possibly that this is a reaction to something that we're not privy to and maybe makes the action make more sense on McClelland's part. But just looking at it cold, I would say that the defense should be allowed to put on anything around people who were investigated as strenuously as those three.
I want to read point 8. Again, these are things that McClelland said should not be brought up in trial. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401, burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. So this also is potentially troubling to me. I want to know, first of all, Todd Click, he's a assistant police chief, I believe, in Rushville.
He's retired.
Yeah, he was at the time of this. Was his investigation, or whatever you want to call it, was it an officially sanctioned investigation by the state police or whoever? Was it totally independent, just something he was doing?
How involved was he? Were Greg Ferenczi and Kevin Murphy, the two men he was working with, were they the primary investigators and he was auxiliary? Was he directly helping them and it was like a trio?
If he is officially involved in an official investigation, it's difficult for me to justify just saying let's totally exclude it.
Yeah, I agree. Also, I think, I mean, now also this kind of ties in. Interestingly, recently, McClelland filed something asking for third-party records from Rushville about possible Brady Giglio issues with Click. So that would what's going on here? We don't know, but it's interesting. I think generally my inclination would be, even though it makes me uncomfortable that they're possibly going to be accusing people based on what seems to me thin evidence at best, I think the defense needs to be allowed to do what they feel they need to do to put on a vigorous defense. I tend to think that allowing them to do basically what they want precludes appeals issues down the road. And, I think that would be to the benefit of all. Basically let them do what they want. I mean, that's just my take. And I feel like possibly a middle ground here is that we're going to see something almost like what happened with the YouTubers at the most recent contempt hearing, right?
Right.
Where Judge Gull let them up on the stand, let them say their piece. Once they got completely far afield, she shut it down. That seems a prudent way of handling things, where maybe there's some relevance, but maybe we're going to get way past that, and maybe let it be while it's relevant, and then once it gets past that, maybe it needs to be shut down.
Point 9. Any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. So I don't know what's going on there. And maybe there's more information out there that we don't have at the moment that would make this clear. But Kevin Horan, former FBI agent, I believe he's testified in over 100 trials, seems to know a lot about geofencing. I'm not sure what the basis would be for saying we don't want him to testify.
One thing that strikes me in this language is findings from any geofence search that is not relevant. So I would be curious what is considered relevant, what is considered not relevant. Are there defense geofence experiments or whatever that are, kind of getting far afield of the facts of the actual murders that are more focused on their suspects? Or, I don't know. But I think, as you said, I would think that an expert with as much experience as Kevin Horan would be definitely allowed to testify as to the facts of the case. So we just don't know.
Point 10. Any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for, that is not an act that is an exception to any Rule of Evidence 404B, and that is not both relevant under Indiana Rules of Evidence 401 and tend to negate the guilt of the defendant. We think we know what this might be about.
This seems like something you would include in anticipation of having witnesses who are like inmates. So if you're incarcerated at Westville, you've been, in most cases, convicted of a crime, and possibly a very serious one, or possibly one that speaks to people's view of your character. And I think what the prosecution is asking for here is essentially like, just because you're incarcerated in Westville on some like meth charges doesn't mean that it doesn't mean that the defense gets to like hammer that again and again and again when you're talking about what you heard Richard Allen say.
It's also potentially a double-edged sword if the defense plans to pursue the idea that Richard Allen is held in awful conditions. So that would mean, I guess, in theory, that if Robert Bastone, the convicted child molester who claims that Richard Allen is being abused, if he testifies, I guess they don't talk about the child molesting.
Yeah. And I think, as you said, it could be a double-edged sword because the defense may also want to bring in their own inmates. So we'll have to see what happens there.
Point 10. Point 11. Any reference to how the files were labeled that were handed over to the defense is part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury. So he's basically saying in all of these motions, they've been trying to create the impression that we've been doing bad stuff with discovery. We don't want them doing that in the trial.
Yeah. And if what the prosecution is saying in their latest filing about discovery is accurate, I think that's completely reasonable. Basically, the defense is just complaining to complain, and we're going above and beyond to help them, even though we don't need to.
Yes.
So I think that's a reasonable request if that is the case.
Why don't you read the final point, point 12?
Any reference to any PowerPoints provided by the state as executive briefs during any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German that are not relevant or would tend to cause confusions of the issues or has the potential to mislead the jury in violation of Rule 401, Indiana Rules of Evidence 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect.
Okay, we know that at different points in the investigation, PowerPoints were made about the case against different suspects. At the very least, we know there's a PowerPoint presentation made about Kegan Kline. And so I'm concerned this is a bit of an overreach, because if a year or so before the arrest of Richard Allen, investigators were preparing PowerPoints outlining the case against someone else, someone who, as far as we know, has no connection to Richard Allen, that's something that I, as a defense attorney, would want to bring up in the trial.
Frankly, I've been baffled by the defense's apparent, from their, filings, lack of interest in some of these other suspects, like Logan and like Kline, because to me, they're better than the Odinist theory. I mean, I'm just being blunt here. I think there's a lot of problems with Kegan Kline as a suspect. I think there's a lot of problems with Ron Logan as a suspect, but I think there's a little bit more, steak than sizzle there, compared to what they're running with. So I'm very curious about this. Is something going on behind the scenes that makes McClelland think that they're going to just whip out these PowerPoints after going on and on about the Odinists endlessly? That would almost seem counter to the defense strategy if they're trying to establish their own concrete theory of the crime. Saying it's got to be these Odinists. But look, there are these PowerPoints of these other guys. I mean, that feels a bit confused. So I'm just this really piques my interest as far as what's going on behind the scenes. Is McClelland covering all his bases here? Does he know about something that he's trying to preempt? Be very curious to learn.
What do you think is going to happen next?
I don't know. I mean, a lot of smart people that I respect have questioned whether the Odinist theory is going to be admitted at all. If it's admissible, is it fair? I mean, I guess that ultimately, to me, is the most important question raised by this document. What's going to happen with that? Because that is the defense's, case. And I've been highly critical of the Odinist theory, but I personally think that they should be allowed to present what they think is the best thing for their client.
Do you think there's going to be a trial in a few weeks?
Okay, well, I really thought there was going to be, there was a week there where I'm like, yep.
You've been all over the place.
I'm in. Well, you and other people convinced me that it was going to happen. You guys were, selling me a bill of goods. Now I'm like, I don't know how they can do it. I also strongly feel that some of the defense's latest motions seem to be some kind of preparing the exit way of oh yeah, we can't do it now, but it's not our fault, Judge. The prosecution's doing it, right? They seem to be kind of making sure that their path to the exit is clear. That being said, things like Brad Rosie saying, well, be available on May 20th, Lacey Patton. I don't know. I think it could still go either way. I'm more skeptical of it now because I feel like the defense posture is of people who are not ready and who are trying to preemptively blame the prosecution for themselves being not ready. And I'm going to say this, from everything we've seen so far, there could be new information that comes to light that changes my mind on this. But from everything we've seen, I do not believe that it is the prosecution's fault that the defense is not ready here. I think that they should take some personal responsibility for that at this point. I think a lot of time has been wasted here from what I've seen. And that's, I don't really feel like it's fair to their client if they go to trial in May and they're not ready. Because again, that is a deadline they put on themselves. No one else told them that they had to do that. So I don't know why you would rush it. Why rush it? Unless you just want to get it over with because you're concerned about your chances. But that's not a good reason.
There's a lot of bad facts in this case.
There's disastrous facts in this case. I mean, this is I tend to think that they would have been better off rushing a trial right in the beginning before he had the chance to confess. But obviously hindsight is 2020. I do not blame them for that. That they could not have known what was coming. But I think he would have been in a way better position had he had a very quick trial in the beginning.
Yeah, enjoy this contemporary reference. With all of these bad facts, the only way there is an acquittal, in my judgment, is if they are Sandy Koufax and they pitch an absolute perfect game.
Oh, a baseball reference. Very nice.
From the Dodgers back in the 60s.
Back in the 60s. Very contemporary.
And I would be concerned that at this point they don't seem to be prepared to pitch a perfect game because of the time crunch. I believe they're still conducting depositions.
Well, if they're deposing this Patton guy, they definitely are conducting depositions. You know, I mean, they're saying that they're conducting depositions.
Anything you want to say before we wrap up?
I just think, like, some of this stuff coming out, you know, I'm just going to say this. Like, I really do feel that there has been a sort of, like, really embarrassing rush to judgment in this case for a while now. And it's, you know, we've frequently criticized, like, you know, maybe people on YouTube or whatnot. But I mean, I think people with higher profile platforms are also guilty of this. And it just seems like so much of Delphi coverage is what people want it to be, want the story to be, how they can twist the narrative to suit their own ends, whether that's to carve out a niche audience amongst people who are more conspiracy minded, or whether it is to cobble together a book about how, you know, Ron Logan must have done it supposedly. And and put that out there. And I think, I mean, I would hope that maybe some of this information coming out has been, you know, sobering to people who were much, much too fast to basically start talking very conclusively about this case either way. But I also don't think a lot of people are capable of embarrassment, so I guess probably not. I think that's probably too much to ask. But I'm just flabbergasted when I see projects that kind of come out and are, you know, just this kind of mess of just trying to carve out a narrative because it will benefit a specific creator.
Yeah, I don't think I know what you're talking about.
Well, I mean, I think I'm not the only one who sees this. I think other people see this, and I think other people are disgusted, and they should be, because I think when you're in the true crime space, you have a responsibility to not just pick the narrative that's most suitable for you or your career.
Yeah.
You have the responsibility to the truth and to be fair. And I don't think a lot of people take that particularly seriously. I'm personally very concerned about the fairness of all of this for Richard Allen, because I think if I were his family, I've said this before, but if I were in his family and I saw this, you know, these filings and this careening towards trial in May for essentially no reason, because they can say it's for his health or whatever, but you know what would be good for his health? Getting acquitted. That would be very good. You know, I would be trying to scramble for some sort of emergency break. And I'm concerned things that have been stated in the past by William Libredo, the former counsel for Richard Allen, where he has effectively said that, well, Richard Allen was concerned that he'd have to pay for his new defense once he got new defense attorneys. I still want to know, where the heck did he get that from? Because that was obviously not true. Libredo and Robert Scrimmin would have been free of charge for Allen. They would also have been public defenders. So where was he getting this twisted information that he would have to pay unless he got Rosie and Baldwin back? I think that's a very important question right now for me as we're hurling towards May.
Yeah, I'm concerned about that too. If he had a full understanding of what was at stake, was he misled intentionally? If so, by whom?
Yes.
I wouldn't be surprised if the defense would try to say, "Oh, we should delay it," but it's the state's fault, so maybe we should let him out on house arrest or something.
Yeah, it's not going to happen.
So
yeah.
Well,
maybe he can start confessing to his neighbors then.
Very well said, as always, and thank you all for listening.
Thanks.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.